So earlier on you heard from Mark McSharry, who quoted a document that was published first on the 31st of August. And just to remind anyone who may have missed it, he quoted a passage that said that it's required now to make a record of a substantial meal or meals ordered by each member of a party or of persons, and each sole person permitted otherwise granted access to the premises. So you would understand from that means if we go to dinner that they write down that Jess Kelly had one thing and Pat Kenny had another thing. However, I have spent the last few hours trying to gain clarity on this, and what I have in front of me now is a document published by the government alongside Fáilte Ireland, and it's entitled Guidelines for Reopening of Pubs. And I want to quote a section to you because the language in this is a bit clearer. It says, businesses and services where intoxicating liquor is sold or supplied for consumption on the premises must keep a record of the time and date of arrival at the premises of a group or sole consumer and the name and telephone number of the lead person in a group or sole customer for COVID-19 contact tracing. These businesses and services must also keep a record of the substantial meals ordered. Foods and beverages must be consumed at a table. So for clarity's sake, what I would like to try and do is give an example. So myself, yourself and our sound engineer Cormac go for dinner. You book the table, so it's under your name and your number is stored. You are the lead contact for contact tracing purposes. We sit at table number 6 and we have our lunch. The bill for table number 6 will have the food consumed at our table along with the beverages, and that is what gets stored. They don't go around saying, well, Jess Kelly had 2 burgers, ice cream and a brownie. It's literally just the food associated with the table that is stored and kept. And if I can just bring you a statement that we have received in the last few moments from Graham Doyle, who's the Deputy Commission at the Office of the Data Protection Commissioner. He says the new regulations introduced by government requiring the recording of substantial meals ordered by each member of a party in a pub restaurant setting involve the collection of personal data. Contact details for one member of a party or an individual person are collected by pubs or restaurants. Details of meals of a dining party will now be added to that contact information. The interference with the fundamental rights in this case is not significant, and the data collected and for the purpose of collection, ensuring compliance with the pub regulations within the regulation, mean it is unlikely to result in any significant risks in the rights of an individual. Where there is interference with fundamental rights, it is not serious. The justification for personal data processing does not need to be weighty. In this case, the stated aim of government in procuring compliance with the regulations through inspections by An Garda Síochána in the context of the pandemic is a sufficient level for the interference that arises. It is not a matter for the Data Protection Commission to decide or comment on government policy. It is the role of the DPC to monitor compliance with data protection law, and in this case the legal basis is sufficient.